Good afternoon, everyone. Good afternoon, Madam Vice President, Your Excellencies, Your Honors, Mr. Registrar, distinguished guests, and dear colleagues. It's an honor on behalf of the ICCBA Training Committee to welcome you to this event on judicial independence. We're proud to host such a distinguished panel and such an engaged audience, both here, online, and apparently some of us in Canada as well. The ICCBA will be marking its 10th year anniversary this year, and we hope that this event will be the start of a series of events marking this milestone. The ICCBA Training Committee strives to create more opportunities like this, a space for meaningful dialogue and practical engagement. But to continue doing so, we need to rely on a strong and active ICCBA membership. So your participation today and your membership is essential. These are grave times globally. In addition, we are witnessing unprecedented attacks on the independence of the judiciary, charged with the task of ensuring checks on those who wield power. And this includes threats and attacks on this very court. So the ICCBA stands united with the judges, with other court officers and this institution facing these threats and attacks. And this event seeks to explore the risks and impact of these challenges to the independence of the judiciary and rules-based international order, and to explore potential strategies and solutions. Our panelists have expressed today a preference for an interactive discussion, so we will not go through formal biographies. Most of you know them well. Their profile were sent to all who registered online for this event today, and they are also available on the ICCBA website. So it's our pleasure to briefly introduce them. We have His Excellency Hugh Adsett, the Canadian Ambassador to the Netherlands. Judge Ibanez Carranza, who sat on the appeals chamber, which dealt with appeal matters in the Afghanistan situation and also dealt with appeals in the Palestine situation. We have Judge Kimberly Prost, who also sat on the appeals chamber that dealt with appeal matters in the Afghanistan situation. We have Judge Betty Holler, who sits on the pretrial chamber currently dealing with the Palestine situation. All three judges are part of the 10 judges currently facing sanctions imposed for carrying out their judicial duties at this court. And Judge Ibanez also faces a Russian arrest warrant and has been prosecuted, convicted, and sentenced by the Russian courts for the same reason. Joining us online as well, we have Professor Margaret Satterthwaite, the United Nations Special Rapporteur on the Independence of Judges and Lawyers, and Dr. Jimena de la Torre, Counselor of the Judicial Council of the Republic of Argentina. The ICCBA Training Committee is represented today by James Onalaya and myself, Mylène Dimitri, your moderators for today. We will begin by giving the floor to Mr. Registrar, and we thank him for his support. And following the Registrar's remark, we will engage with our distinguished panelists in substantive discussions on these issues. And this will be followed by an opportunity to put questions from the participants either in person or online. We are not often given the opportunity to keep judges within strict timeline. So we will do it, but very discreetly. You're both going to have on both sides someone showing you the time left in order for us to remain on schedule ahead of the closing remarks by the ICC Vice President, Madame Judge Alapini Ganzu. Un remerciement particulier, Madame la Vice-Présidente, pour votre présence et votre soutien. And for those joining online, if I can please remind you to put your microphones on mute. And for those in the room, if you don't want us to stare at you, I will kindly ask you to switch off your phones. So it's now our pleasure to give the floor to the registrar, Mr. Zavala Gillier.
Dear judges, excellencies, dear ambassador, esteemed members of the ICCBA, colleagues, let me begin by expressing my thanks to the ICCBA and to Milan in particular for convening us today to reflect on a matter of importance, the judicial independence and the protection of the international rule of law. A few issues demand our attention with greater urgency. We are indeed living through perhaps a defining moment, a moment that is testing in real time the principles that we have built over decades and how these principles can withstand the pressures that are now bearing down upon them. Across the world, the international legal order is under increasing pressures. We are witnessing increasing challenges to the authority of legal institutions, nationally and internationally, and deliberate efforts to weaken accountability mechanisms, as well as attempts to reshape norms that were once broadly accepted. And the consequences of this are far-reaching. When the rule of law is weakened, it is not institutions alone that suffer, it is individuals. It affects due process and rights of all parties. It affects victims. It is those most vulnerable who are left without protection. And it is trust in justice, which is so difficult to build, but yet so easily eroded, that is placed at risk. At the center of this environment, at the center of this moment, the court stands. And so do all of our roles. We operate in an environment of sustained, multifaceted threats. We face repeated cyber attacks. We are targeted by coordinated disinformation campaigns aimed at undermining confidence in our work and questioning our legitimacy. 8 judges and the prosecutor have been condemned in absentia by the Russian Federation to prison sentences of up to 15 years. Sanctions have been imposed by the US against elected officials of this institution, 11 of them, with threats to further escalate these measures, extending them to the court as a whole. And yet, this is not a temporary phase. It is the context in which we now work every day. And it is likely to remain so for the foreseeable future. But I want to say that there's also another way of understanding this reality. Institutions that do not matter are not attacked in this way. No one expends efforts, resources, or political capital to undermine what is irrelevant. The intensity of the pressure that we face, paradoxically, is also a measure of the court's significance. It tells us that our work matters, that it has an impact, and that it is seen and that it is felt. And for that very reason, it must continue. Our mandate is grounded in law, in the will of 125 states, and in the expectations of victims and affected communities around the world. To fulfill that mandate, one principle is indispensable: independence. It encompasses the judiciary, the office of the prosecutor, the defense, the legal representatives of victims, and all the support functions played by the registry. Justice is not the product of a single actor. It is the result of a careful, balanced system in which each component plays an irreplaceable role. So when you remove one element and fairness is compromised, you compromise fairness and legitimacy cannot endure. And at the heart of this system stands our judges. They carry the ultimate responsibility of ensuring that the proceedings are fair, that rights are respected, and that decisions are grounded in law and evidence. And in this time, our judges have continued to discharge this responsibility with incredible professionalism and resilience. They have rendered decisions in complex and highly scrutinized situations, remaining faithful to their judicial oath despite of any external pressure or criticism. This quiet resilience has been essential for the court and ultimately for the protection of the international rule of law. That is precisely why independence must be defended. And we must protect the independence of all actors of the system because they are independent parts of a single pursuit, which is justice. A pursuit that is inherently challenging. This is because this is a system that insists on evidence over power, on law over force. And this will inevitably be resisted by those who would prefer it otherwise. Allow me to conclude with one final reflection. This court was not created for easy times. It was born out of the profound failures, moments when the international community recognized that impunity for the gravest crimes could no longer be tolerated. States made a deliberate choice to establish an independent institution capable of delivering accountability, even when doing so is politically difficult, even when it is resisted. In other words, this court was designed for moments such as the ones we're living through now. And that carries with it a clear responsibility, a responsibility to preserve, to remain steadfast, to uphold without hesitation the principles upon which this institution is built, but also a responsibility to do so together. We will continue to do our job. The court as an institution and its state parties have stepped up to support and defend them, reaffirming in clear terms that judicial functions must be exercised free from intimidation and interference. And today we renew our pledge as every day in the exercise of our mandate. Today, as every day, we stand alongside our officials targeted and affected simply for doing their job without compromise and undeterred. Today, as every day, we carry on together. Thank you.
Thank you, Mr. Registrar, and thank you for underlining that if we are indeed under attack, it's because this institution does matter, and it matters to all of us. Without further ado, I want to give the floor to Madam Special Rapporteur. I have a series of 3 questions. I'm going to start with the first 2. The first one, if you could give a brief definition of international rule-based order and the international rule of law and why it's important. After which you could follow up by answering the following question. In many national systems, judicial independence is safeguarded through structural separation from the executive and, in some cases, life judgeship appointments. How should we understand the targeting of international judges by non-state party actors, including sanctions or criminal proceedings in this context? Do such measures risk creating a perception that international judicial institutions such as the ICC are inherently political, or do they rather reflect external attempts to politicize or otherwise the independent judiciary?
Thank you very much for these questions, and I want to thank you so much to the ICCBA for the invitation to participate with you. So, I mean, this question of what is the rule of law at the international level is so important. It's really a bedrock guarantee for any system. It ensures that power is exercised with accountability and according to the law, and that arbitrary will of the powerful can't overtake the interests of those who would otherwise be at their mercy. The World Justice Project defines the rule of law as a durable system of laws, institutions, norms, and community commitment that delivers four universal principles: accountability, just law, open government, and accessible and impartial justice. At the international level, the rule of law is an outgrowth of the agreement by sovereign and equal states to not allow force to triumph over legal rules, to ensure that the rights of all human beings have and must be protected and respected by any and all actors, weak and powerful alike. International criminal law is an essential part of this system. It ensures that the most grave crimes will not go unpunished, and that those who would seek to discard the limits of their power by using human beings as a means to an end cannot prevail. Now, the International Criminal Court and its personnel, the prosecutor and his staff, the judges in their independent roles, have become central targets of those seeking to erode and hobble the international rule of law. And this is because independent and impartial judges and prosecutors who are charged with applying law to facts without fear or favor pose a threat to the untrammeled power of so-called strong leaders when they seek to use their power without consequence. And so by insisting that no official, even those who lead powerful states, can be immune from the ordinary application of the law, by making real the promise that all victims are equal in dignity, international judges and prosecutors are seen as an obstacle to overcome. And thus they become the targets of actions that directly punish them solely for carrying out their impartial legal work. Now, these actions, the cynical use of criminal law as a reprisal against judges of the ICC, the sanctioning of prosecutors and judges of the court as though they were terrorists, and the personal attacks and denigration of personnel of the court are themselves the political acts and efforts to minimize and even obliterate the moral and legal truths that are the product of international criminal law.
Thank you. And what normative or legal tools exist to respond to this emerging from form of pressure against the international judges?
So I believe we're going to discuss the specific steps that states can take, and also that the UN can take a little bit later in the program. But what I want to say now is that the legal and normative framework is absolutely clear. It is unlawful for states to seek to intimidate, punish, threaten independent judges and prosecutors in order to influence their work. These actions violate the bedrock principle of the independence of the judiciary, which is the center of our discussion. That principle sits at the heart of human rights law, enshrined in the Universal Declaration of Human Rights and the International Civil and Political Rights Covenant, as part of a right to a fair trial, and it's inherent in the access to justice that we all require, and the right to be equal before the law. Now, both states and intergovernmental institutions have an obligation to act to protect these rights and to reject reprisals and attacks on the administration of international criminal justice. Just as we must protect domestic rule of law against rising authoritarian attacks, so too we must act in concert to push back against the use of would-be autocrats of reprisal and threat to shut down impartial criminal law. And I believe very strongly that the bar across the world has a specific role to play in defending the institutions that are under attack, and in particular in coming to the aid of independent judges and prosecutors when they come under attack. So I'm very happy that this event is happening today because it's part of that effort to speak out clearly in support of the rule of law.
Thank you very much for that. Can I bring Dr. De La Torre in, please, if I may? Doctor, can you assist us with what role you think the judicial independence plays in ensuring and maintaining the international rules-based order? And what does Argentina's institutional experiences from the trials of the military juntas and its commitment to the Rome Statute through to the present day, of course, teach us on how that independence can be built, lost, and then recovered again? Thank you.
Good afternoon. Thank you, everyone present. I would like to express, first of all, my gratitude to the ICCBA for the invitation, our moderators, Mylene and James. I'm also truly honored to join such a distinguished panel. It is a privilege to share this conversation with all of you. Let me start with a brief clarification about the perspective, from when I speak today. I am not an ICC litigator and I'm not a specialist in international criminal law. I am speaking today as an Argentinian lawyer serving on the National Judicial Council. My work there focuses on judicial selection and appointment, how judges reach the bench, under what rules, and with what consequences for judicial independence. From this position, I believe that judicial independence must be designed, built, and defended. It must be designed through the rules of selection and appointment, built through institutional culture, and defended when political, economic, and geopolitical power seeks to shape or constrain it. The international rules-based order relies on a simple but crucial premise that rules apply to everyone. The moment that this premise collapses, the system loses its authority and becomes more about convenience than law. A court can only hold the weak responsible is no longer a true court. It becomes an instrument of the strong. International institutions were born to the understanding that disorder, war without limits, state crime, and impunity had cost too much. It, that was one of the great lessons of the 20th century. Power without rules that does not produce freedom, it produces devastation. Argentina knows of this from its own history. The trials on the military juntas were a historic precedent. They showed that a country could prosecute through its own civilian courts those responsible for grave human rights violations committed from within the state itself. That experience showed that justice can be part of political reconstruction. From this conviction, Argentina played an active role in the negotiation of the Rome Statute. It was ratified early and was the first country to sign all four cooperation agreements. It incorporated crimes against humanity into domestic law with a depth that few comparable systems had achieved, and it contributed to the work of the court through figures such as Silvia Fernandez de Gurmendi, who served as president of the ICC between 2015 and 2018. So Argentina did not simply receive this system, it helped to build it. That is why Argentina today is more than an observer, it is also a warning. The current government posture towards the ICC marks a break with this tradition. And that teaches an important lesson. No institutional tradition survives on its own. Institutions do not survive through inertia. They survive through conviction and through the decision to defend them when they become inconvenient. This also leads to a point. Support for legal multilateralisms is not only moral, it is strategic. Countries that believe in the rule of law and in individual rights have a direct interest in the staying engaged in the international institutions. Leaving those institutions does not make them disappear, it only leaves them to others. This is why Mark Cartney's phrase is so useful today. If you are not at the table, you are not on the menu. The task, then, is not to idealize institutions. The task is to acknowledge their flaws, their inefficiencies, and their errors, and nonetheless remain in them with greater seriousness, greater conviction, and a deeper commitment to their reform. Let me close with this. Judicial independence is not only a domestic constitutional value, it is also a condition for any real international rule based order. Without independent courts, rules become optional. Without independent judges, accountability becomes selective. And when accountability becomes selective, law begins to give way to power. Argentina's experience teaches both hope and caution. It teaches that justice can help rebuild democracy, but it also teaches that no achievement lasts unless each generation chooses to defend it again.
Thank you, Doctor.
Ambassador, I have two questions for you. I'll start with the first one. How do governments engage with courts and their decision-making processes, and why do states choose to intervene in proceedings?
Merci, Mylène. Et nous avons des traductions, oui, ou il y en a une interprétation aujourd'hui ou non? Il y en a. OK, je vais commencer juste avec quelques mots en français. Juste pour commencer, pour dire merci beaucoup à la ICCBA pour l'invitation aujourd'hui. Je crois que c'est un sujet, un thème très important. Et je voudrais aussi remercier les juges qui sont ici avec nous autres, qui ont servi la communauté internationale avec courage depuis plusieurs années, et je suis très honoré d'être ici avec vous. I thank you very much for the opportunity to be with you this afternoon to say a few words. And I thought, as I was thinking ahead of time about the questions that you had asked me to reply to, of a couple of things. And let me make a couple of points, which I hope will lead into a bit of a broader discussion that we're having this afternoon on independence, but also the role of states when it comes to engaging with international tribunals of various types. And I use the word engage deliberately. Because I think there is a role for states to engage with international institutions. And it's not necessarily, although it can be perceived as such, it's not necessarily the case that engaging, even in situations where the engagement might be to offer suggestions or criticisms, that that's necessarily a bad thing. I think, in fact, it's quite constructive. But let me start with your first question first, and then with time remaining, I'll make a couple of additional points. Let me start with the ICJ. It's an institution that Canada has a fair bit of experience with. Many of you know the provisions of the ICJ statute quite well, but Article 63 of the International Court of Justice statute, and I'm just going to read this briefly, says, whenever the construction of a convention to which states other than those concerned in the case are parties is in question, the registrar shall notify all such states forthwith. Sub 2, every state so notified has the right to intervene in the proceedings, but if it uses this right, the constructions given by the judgment will be equally binding upon it. we've intervened, Canada has intervened under Article 63 in a couple of instances, Gambia and Myanmar case, for example. Ukraine versus Russia is another one. And what we seek to do by intervening in these cases is to help the court. That's the objective of this, is to help the court, ideally, with providing our understanding of how the convention ought to be interpreted and how the convention ought to be applied. There's a provision for that under the Vienna Convention on the Law of Treaties, which provides that the practice of states parties is important in understanding how an instrument's to be interpreted. And there's also the opportunity for states to contribute by helping a court understand customary international law, which I think everybody here knows quite well based on state practice and opinion juris. Again, though, the context for these efforts to provide our views is to assist the courts and to better understand the perspective of a state in our case, or the perspective of states on what the law is and how the law could apply. We consider a range of factors, Canada considers a range of factors when we're deciding whether we would intervene in a particular case. Would our participation, for example, bring a perspective or an issue that perhaps hasn't been brought forward by others? Is that part of what we can contribute? Maybe it helps to add to the diversity of views that have been expressed, to add to a consideration that's been overlooked, to think through a complex issue of law in a way that, that brings a different aspect to it or shines a different light on it. We might even put forward views that are different than those that have been held previously. But, again, and I think we're in a crowd of lawyers here, everybody will understand that is a constructive effort to try to help support the law, because at its base, what we're trying to do is, I think, in many ways, the same thing. We're looking for the rule of law to be adapted to the circumstances that we face in order that the rule of law becomes the basis for the action of states. To get maybe to the registrar's comments in your intervention right off the top, the rule of law, when it functions, is a mechanism to protect the most vulnerable. And the rule of law is important for that purpose, whether we're looking at domestic law or international law. And if states can contribute to making that rule of law most effective and efficient and comprehensible and appropriate, then I think it's a role that states should and do take on. And it's one of the considerations I know that we have. Just maybe briefly, because I know we want to move on to other aspects of the question or other questions as well. There's also provisions with the Rome Statute that you know quite well. Article 97 provides the opportunity for states to consult in appropriate circumstances. And it's another mechanism of engagement. It's another way in which states and the court can have an exchange of views on the law and hopefully, ideally, lead to the best outcome in individual circumstances. Thank you. I'll stop there.
Thank you. And on what you just said and the examples you gave and the fact that the state can offer different views and constructive efforts to intervene in order to improve certain matters, is there scope for legitimate criticism of courts by governments and state officials? And how do you demarcate between legitimate criticism and unjustifiable attacks on judiciary or courts?
Yeah, Milan, thank you so much. I love this question. And I love the question for a couple of reasons, because I think it's an important question. I think it's in some cases, it's a very live topic these days. I worked as a journalist early on in my career as well. So it actually, when I was in journalism school, and this was a long time ago, but there were also discussions in journalism school as well about the proper role in civil society of criticism of judges. And certainly I know it's a live issue for lawyers too. It is absolutely proper for individuals to take critical stances if they disagree with the outcome of a particular decision. it's absolutely improper to turn that into personal attacks on the judges themselves. And I think sometimes what that comes down to is having an understanding of both the role of the judges, and I'm sure we're going to hear more from the bench today on this, and the limits that they have as judges in being able sometimes to speak publicly about choices they've made. I think that maybe we'll hear the line that the judges speak through their decisions. But at the same time, I think it's quite proper, whether it's an international organization or in our own societies with domestic courts, to take a critical perspective. Because, again, to use maybe an expression that gets a little bit cliched or a little bit overused, but I actually can't think of a better one, there is a conversation or a dialogue that can take place. And fair criticism, absolutely, I think, is part of that. And again, the judges will speak more to this, I'm sure. But when I sometimes read some judgments of some jurisdictions, even between judges themselves, there can be quite spicy comments and dialogue's a nice way to put it, but sometimes quite blunt differences of opinion. Again, that's not really for me to speak to. I do think, though, there's an important line not to cross, and it is the line of personal attacks on the judges themselves, and obviously other more other stronger efforts. So, for example, sanctions and other efforts to curtail the independence of judges are completely inappropriate. The judges, whether you're looking at a domestic system or you're looking at the international tribunals, we've asked them to do this job. It's not the other way around. Judges have not created the world of international criminal tribunals because they were looking for work to do. It was states that wanted this work to be done, and the reason states wanted it to be done this way, and the reason states created tribunals, was because we saw the importance of having independent adjudicators decide on these most difficult issues and to ensure there was accountability. But we've asked for that work, and we've asked for judges to take this role on. I think the least that can be done is that we respect the fact that they are taking on that role and in some cases having to make difficult decisions. So there is a line. Having said that, my point of view, it's absolutely not inappropriate for there to be criticism. I think that's fine. I think my sense is that most judges actually do not mind fair criticism. Obviously, we'd all like to have all of our decisions warmly welcomed, but I think that is a part of that dialogue that's important to take place. But there is a line that should not be crossed, and that is the personal attacks, and that's the restrictive measures taken against individual judges as well. Thank you.
Thank you.
Thank you, Ambassador, for that very clear demarcation line. Can I turn now, if I may, to Judge Huller? And we know fully well that you are one of the judges facing more than fair criticism right now. And really would like to hear from you as to what the impact is of these coercive measures, the sanctions, the criminal procedures against court officials, and the impact on the working arrangements of this court. And indeed, what, if any, do you envisage is the impact on this court's goal to end impunity?
Thank you very much, James, for that question. And I want to start by expressing my appreciation to the ICC Bar Association for convening this discussion around this, like we've heard, very important topic, a topic that's important not just at the international level, but also, I would say, at the national level, as many national jurisdictions are also facing similar issues. And I want to thank everybody for being here and having this conversation rather than running off to the beach in this uncharacteristically warm weather. Now, to the question that you have asked me to address, and that is what are the impacts on of these coercive measures on the workings of the court. And I was thinking about this, and I think you can see them, or I see them, in sort of three concentric circles. I think there's three aspects, essentially. One is the impact on the work of the individual, of the elected officials that are being targeted. The second layer is the impact on the institution as a whole, on the International Criminal Court. And then the third layer is the impact on the Rome Statute system as such, because of course the Rome Statute didn't just create an institution, the court, it created a whole system. And that goes in line with the second aspect of your question of the impact on the global fight against impunity. Now, if I start with that first individual impact, I'm not going to go into all the disruptions we face. We've been quite vocal about this, the affected judges. I'm sure you've read or heard about our troubles with the credit cards and the bookings and the IT. But what I will say is this. Do these coercive measures affect our daily lives? Yes. Are they disruptive? Certainly. Do they affect how we approach our work and our decision-making? Absolutely not. We continue to carry out our responsibilities the way that we always have, independently, impartially, purely on the basis of law and evidence, and to the best of our abilities. And we have also been, all of us, all 11 affected officials in one way or another, either through the Russian criminal procedures or through the sanctions, very vocal about this. And we stand very firm. And simply because that, I think, is what the judicial oath requires us to do. So there's no debate about that. And I also want to say that while, Judge Ibanez, Judge Prost, myself, and the other judges might be personally affected, might be the ones whose credit cards have been taken away, we also know that the target of these measures is far broader. And I would say it's not even only just the institution, but it is the very idea of international criminal justice. It's this very idea that those who are responsible for atrocity crimes should be investigated, prosecuted, and brought before the court for fair proceedings. And essentially what that means is that when this idea is under attack, the goal is to restrict the victim's rights, victim's access to justice. And I always think that there's some irony in the fact that the states that are currently imposing measures on the ICC officials are two states that are actually responsible for the birth of international criminal law in the first place 80 years ago in Nuremberg. Now, second is the impact of coercive measures against individuals on the workings of the institution. To this, the registrar could certainly say much more than I can. But what I can say is that there has been some impact on the way how we organize our work. And the court, of course, has had to adjust in light of these measures certain internal protocols. It has had to adopt policies that were not there before. But that is not in itself bad, I would say. It was probably wise to do so anyway. The registry is conducting a review of business relationships with external service providers. And as it has been publicly reported, the ICC has started transitioning to a new digital workplace system. And this situation obviously requires difficult decisions and is driving a significant, I would say, institutional transformation. And as the registrar has, I'm quoting him now, although he's sitting in the first row, has always underlined that two principles of this are resilience and adaptability. And what I would add there is that the court being put in this position of having to essentially innovate, because it has to, because it's under attack, is also an opportunity for the court to make improvements and to also perhaps show the way to other institutions that could find themselves under attack in a similar way in the future. In terms of the impact on the Rome Statute system as such, again, I think when it comes to engagement of external actors with the ICC because of any impact of sanctions, I think the registry and possibly the office of the prosecutor will be better placed to discuss that. We as judges do not have immediate communications with external parties, as you will understand. But the Coalition for the ICC, who last week published a comprehensive report on the impact of sanctions, has documented that there has been some chilling effect on external parties, be it human rights defenders and others cooperating with the court. Now, here I also want to emphasize that the staff of the court has shown immense dedication and resilience. And it's not just staff, it's also members of the ICC Bar Association and all others who work with the court. I would say the challenging times, as I had hinted, also offer an opportunity for progress and improvement. And I think that is very, very possible, very, very positive. And I am running out of time and being told to conclude, but I will take another 30 seconds to briefly address the third point that I wanted to mention, and that's the impact on criminal justice as such. Now, I am not pessimistic when it comes to the future of international criminal justice. Although this institution and maybe the system as a whole is under significant strain at the moment, I think it's also very important to remind ourselves that there are many positive developments. One, for example, is the fact that although the ICC is facing bigger challenges than ever, it is also busier than ever. It is continuing to deliver landmark decisions and judgments and contributing to the development of procedural and substantive criminal law. At the same time, the efforts at the national level for investigation, prosecution, and adjudication of international crimes are increasing. Argentina is one of the countries that is conducting such proceedings, and a number of European jurisdictions as well. I will stop there and give the floor back to the moderators.
Thank you very much, Judge.
Thank you. The next question is for you, Judge Ibanez. So as a judge who has been personally been targeted by measures from two non-state parties, how do you safeguard your judicial independence in the face of external pressure, including sanctions or even criminal proceedings initiated abroad?
Thank you. Thank you for the invitation to the ICCBA. It is an important opportunity to discuss other dimensions of this problem currently the court is facing. Let me start by recalling what is the nature of judicial independence and what is at stake when this independence is attacked. According the United Nations basic principles on the independence of judiciary and the Bangalore principles, judicial independence is a threefold dimension, has a threefold dimension. First, as Bangalore principles describe, it is a value and it is a prerequisite of the rule of law. And for me, it is a pillar of democracy as well. So when this value is shared by the United Nations and the international community, and it is intertwined with the second dimension, that it is a fundamental guarantee of a proper administration of law. It is enshrined with human rights of equality before the law and to a fair and public, the right to fair and public hearing by a competent and independent tribunal and judge. And of course, it is linked to the right to be tried without delay. All of these human rights enshrined early by the Universal Declaration of Human Rights and further by the ICCPR and the International Covenant on Economic and Social Cultural Rights. And it's important this because only the third dimension is described as an individual both right and duty of a judge to be performed and defended in the discharging of their duties. And as such, it is protected in legal systems across the world as it is settled in Article 1 of the United Nations Basic Principles. So when judicial independence is attacked or threatened, all of these three dimensions are affected simultaneously. And this is why these attacks and threats affecting human rights, warranties, and proper administration of justice are not truly a personal, how can I tell you, are not truly personal against the judges. They are directed to individuals, it's true, like it is now at the ICC, but the real target here is the system. The real target is not only the court, but the system, as it has been described also by the panelists who have spoke before. The current states of affairs show that it is not a personal or individual issue, but an institutional one that concerns also to members of the Rome Statute and the international community as a whole. So, how do I safeguard this? I think that this question only approaches this individual dimension. I mean, it will be easy to say a lot, but personally, as you may know, as you just referred, I have been targeted by the big political power of the East. I have been subject to an arrest warrant from Russia and also to a trial, to prosecution, to conviction, and to sentence. I don't know why, because I never saw the case. And when it came, I was the first vice president of the court, and only for being the first vice president of the court and part of the presidency that at that time ran the court. It's also to be executed by states allied with Russia or for the military, private military groups such as the Wagner Group, or for countries that have agreements of extradition with Russia. So the issue is not minor. With respect to United States, also you know it came against me as a cancellation of visas, as a cancellation of FABs, credit cards, but the issue didn't stop with me. They were extended to my daughter. She's a different person, a lawyer who has nothing to do with the ICC, who hasn't any connection with my job. Then how do I safeguard my judicial independence on the face of this? You know, being a prosecutor in my country for 35 years really trained me to face this kind of attacks. I was attacked by the terrorist groups. I faced attacks against my life, against my integrity, against the integrity of my family. I have faced attacks from the political actors, very high-ranked political actors. So I have grown resilient. But I wonder if it's the sole response we need before these attacks in the international court. I don't think so. I think that resilience is not enough. It's not enough because important thing here is that we need also the support and the concrete actions from the states, from the institutions. This is a systemic attack. Thus, the response should be systemic.
Thank you. You answered my second question when you when you said that resilience is not the sole response. We need the support of state and institutions. So I'll ask you the
But I would like perhaps
You-
add something else to this, just one
let me
point.
develop my second question. So you
Okay, okay.
can. So in your experience, what matters more in preserving that independence, the support of states and institutions, or the personal resolve of judges to remain unaffected by such pressures? And is there a point where ignoring such measures becomes unrealistic and institutional protection becomes indispensable?
Well, as I said, and I would like here to point out that the answer is clear. There is not a choice between the two. Both should go together. It's not a matter only of individual resilience. Personal integrity, of course, is essential. Judges must remain steadfast, independent, faithful to the law. This is our duty. But even the strongest judge operates within a system. Now, in this case, this is because the Rome Statute has been attacked as such. This is without doubt that the system needs to respond as such as well. The measures that we have been just discussed are designed to destabilize the institutional framework of international judges. They affect the functioning of the court. And this is why the institutional support is not optional, it's a responsibility. Now, all of these kind of attacks, threats, and special measures against us from the East, from the powerful actors from the West, which happens also to be members of the United Nations Security Council, who sends us cases, cannot be ignored. We have already reached the point where we cannot ignore these attacks. This disrupts everything. And again, I should stress that the institutional support and protection for the judges and for the court remains indispensable. The response must be structured, coordinated, and effective. It should include legal defense for the court and for the judges. I'm so happy what the registry is doing. I'm so happy about the news from Ambassador Atzet. But now I'm wondering why me as judge, as individual, should defend legally only by myself. There's no a policy, there is no a practice, there is no legal framework, perhaps, I don't know. And I don't know if there is a will to give or to grant legal defense for the court and for the judges. Even before international justice tribunals included also tribunals in United States. Why not? Because this is the only way that we could perhaps achieve to remove this kind of measures, not for me, not for the judges that currently are in the problem, but for the court, because we are doing nothing. We are men and women of law. And from the point of view of the law, what are we doing? Only individual efforts from judges. It is not only just, but I think that we should think in a systemic manner on this. Thank you.
Thank you very much, Judge Ibanez. And I will turn, if I may, now to Judge Prost. And we've heard quite forcefully and passionately from Judge Ibanez the need for institutional protection. And indeed, of course, the fact that we've heard some ideas of things that can be done. I suppose perhaps this question may already have been answered, but I'd like to hear from you in essence, which is, are the current state responses that we have seen internationally sufficient? Or is there a need for more? And in particular, really in terms of coordinated and collective responses? Thank you.
Well, thank you very much, and let me add my thanks to the ICCBA for the opportunity to be here today and to join in this discussion. You know, the question of reactions and support and responses by states, I start with recognizing that this situation is a very challenging one for everyone, including the states, so I fully recognize that. But I'm going to speak very frankly from the perspective of a judge, from the perspective of a sanctioned judge, as to what my expectations, our expectations are of what can be done. And I'm focusing on state responses here. You know, and first and foremost, states parties have to publicly support this court with statements of support, with political statements. This, as Ambassador Ad said, so well put, this is not the judge's court, this is not the prosecutor's court, this is the state's court. So it is, to me, instinctive that there should be this political support and statements at appropriate intervals. And I have to say that at the beginning of this whole saga, it was tremendously disappointing and frustrating to the sanctioned individuals, to the judges, to the court, to the staff of this court, that there seemed to be an inability for collectively the states parties to make statements on this situation. And that was an expectation we had, and I think it was a realistic one, and it is the responsibility of states. So I'm emphasizing that, even though I am now going to be able to say there's been much positive development in this respect, because I don't want states to lose the message as to how disappointed we were at that initial phase. But we have really advanced. And I think all of us who were there at the ISP this year would say that was a watershed moment where you could feel the coming together of states. You could feel the support. I saw ambassadors sitting in the main room. I've never seen ambassadors sitting in there, with all due respect, Ambassador had said, but they were sitting listening to other statements, and they were delivering strong statements, and that was all extremely important. And the issuance of the declaration, sure, there's compromise language, that's the business, but that was a really watershed moment. So that's a message I wanted to convey on that point. Secondly, and it's perhaps because I lived this world when I was ironically the ombudsperson for the Security Council Al-Qaeda Sanctions Committee, that I learned, I was there trying to trying to advance the rule of law in an extraordinarily stubborn context. So it seemed to be a concept that was unknown. And one thing I learned was you need to speak loudly, but you also need to speak quietly. So I hope that in parallel, and I'm confident states are also having those conversations, having that engagement, because that is equally important. But the third thing, and I speak to it, you probably heard me ad nauseum, on the point of practical measures that states have to take to support judges, what Judge Urbanis was speaking about, judges, the prosecutors who've been sanctioned, all the sanctioned individuals. We need practical support now to minimize the impact of these sanctions. And this is a field where the registrar is certainly advancing this point, but I want to make this very clear how important this is. This is about lessening the burden on us. We should not be left to have to manage these issues. Judge Bossa says it to me sometimes. Are we just alone in this? Is it just left to us? No, it shouldn't be. And there's lots of talk about the blocking statute here in the European Union, and I understand blocking statutes well. I know their limitations. I know that it's a political question, and there's blocking statutes in other countries as well. At the very beginning, I don't think it was necessarily the moment to jump to those statutes, but we are now in a situation when we're talking about companies and agencies that are not required to comply with these sanctions. We have a French company denying the medical claims of the sanctioned judges and prosecutors. We're not getting paid our medical insurance despite a contract. It's a French company. I can't do a transfer, not because we're not well supported, which we are here in the Netherlands. I can't do a transfer, successful bank transfer in Europe because all the banks keep bouncing my transactions. I think it's time. Now there's enough time, now there's enough experience. So I really think the blocking statute is something that should be seriously advanced. But I know politics, so it may not be advanced. So in the interim, there are simple things we can do because companies have to be made aware, states have to be better at engaging with private industry to make this point clear to them. It's very simple. You are not obliged by law to comply with these sanctions. And if you're taking a business decision to do so, you are complicit. You are complicit in threatening judges with a view to getting them to decide their cases in a special way. You are complicit in compulsory measures that are designed to interfere with the independence of the judiciary. And I don't think private industry in Europe and Canada, elsewhere in places I've been, understands that that's the situation. And there's simple things. Part of the problem here is compliance is built. I saw this operate from the other side. Compliance mechanisms are automatic. So my name, it goes in and the transaction gets stopped. Why is there not a separate list that's sent to compliance agencies saying, for these particular sanctions, do not automatically implement? You can't tell them what to do, but stop and think, is this the best? Oh my goodness, 1 minute. Well, I have so much to say. No, I'll behave myself. Just to have that kind of a simple measure, make them understand. Canada was very helpful to me in this respect because they have taken very specific measures with industry to make this point clear. These sanctions aren't binding. She's a very nice person. You shouldn't impose these sanctions on her. So give them the information. I have actually seen private industry, a bank, that without anyone's prompting had a whole meeting about me and took the decision not to exit me, a good business decision. So those things can be done. And in addition, we need this network. I've been talking to the registrar about this quite a lot. We need a network of contacts in the various countries, all of the ASP state, all of our states, because I'm not having problems in the Netherlands, or just in the Netherlands and Canada. I'm having problems with banks in Denmark, in France, in New Zealand, all states parties. Why can I not just go to a network contact and say, this is my problem? The United Kingdom, not only do they reject my transactions, but there's banks in the United Kingdom who have frozen my funds and sent me an email telling me my funds were frozen, the bank did, under US law. And if I wanted my money back, this is literally, I had to write to OFAC. Well, how is that possible? Anyway, I have to stop, but I'm just a bit fired up. Anyway, so what can states do? There's some measures, and if you want more information, I'm available. Thank you very much.
We're very grateful. Passion, more passion, please.
Ambassador, I'm going to put the pressure on you now. You heard Judge Prost, her disappointments, her expectations. So what practical steps may be taken by the Assembly State Party and by individual state parties to protect the ICC, its judiciary, and individuals and organizations who work with the ICC from the impact of such threats and attacks? And from a state perspective, how can government effectively protect its national serving at the international level as judges?
It's always hard to follow Judge Prost. I can confirm that she's very nice. So look, and actually, I on this one, I think in a way, I'll be relatively brief, actually, because I thought that was it was a good segue because the examples you gave are actually really illustrative of the challenges, but also some of the solutions and options and things, which I think actually many states are working on, including ours as well. So I'm going to talk just about a couple of things. One is, without getting into the details, I do think one of the most important thing that states can do, and Judge Prost was really referring to this at the end, is find practical ways to facilitate. And there are practical measures that states can take. I'm glad that those communications are happening, because I think that is a big part of it, is opening up those discussions and making sure that those who need to talk about the practical measures do so. But that's probably not a discussion. That's probably not a discussion here, but there are practical things that can be done. The other couple of points actually move on a little bit from specifics, but a really important thing that states parties can do is support the ICC registry. And there's a couple of ways of doing that. I know this may feel a little bit indirect to the issue that sanctioned judges are facing, but I actually think it's important, particularly for the institution as a whole. So paying contributions early or on time. Early is even better. On time is a must. The court can't function without states parties making their contributions. It just simply doesn't work that. We've had, I think the registrar would agree, good response from states. That's excellent, but we need that to continue and to be maintained. There's other contributions that states can make. Secondees, for example, also an important contribution that states can make to the work of the court as well. And the ASP declaration, I wanted to come back to that for a second, because I'm glad it was mentioned, because I do think it was really important, substantively, also illustrative of just the reality that it takes states time to coordinate amongst themselves. And there are a lot of perspectives that have to be taken into account. Diplomats, I think, are used to working in that world, but it does mean sometimes that the responses are not as, it takes time. That's maybe I'm going to say they're slow, right? I mean, that's just the reality of trying to coordinate amongst a large group of states. I do think that is something that states, though, can consciously start to do better at, which is to work more swiftly and to work more closely together to come out with statements at appropriate moments in time. But I was very glad, like I say, to see the reference to the declaration, because I also thought that was quite significant and quite important. And yes, there were ambassadors who showed up, but we do show up. But it was true that there were maybe a lot more than usual in the room at the time. Thank you.
Thank you. I will come back with with another small question, but first I want to ask Dr. De La Torre, drawing on your experience in judicial appointment processes, Doctor, what institutional and systemic safeguards need to be built into the design of judicial selection at both the national and international level to ensure that judges can resist external pressure throughout their careers? And what does this tell us about where the defense of judicial independence truly begins?
Okay, thank you so much. Well, I was listening to my prior partners here, and I was rearranging my presentation. Let me begin at a central point that I learned from my experience in Argentina and in the Argentinian Judiciary Council. As Judge Ibáñez Carranza and the other ICC judges illustrated us very well, the defense of judicial independence does not start when a judge resists the pressure. It needs a systemic response. And from my humble perspective, the defense of this judicial independence should begin much earlier with the method of selection. ICC judges teach us that individual courage is critical, but this judicial independence is not simply about personal integrity. It is an institutional product. It is the consequence of design. A judge who arrives at the bench through a transparent, competitive, rigorous, and objective process carries a legitimacy that is different from one who is appointed but by pure discretion. A judge whose appointment minimizes prior dependencies is far more independent than one whose selection is tied to patronage or pre-existing political loyalties. The future of autonomy of a judge is shaped, at least in part, by the institutional quality of their selection process. This is even more delicate in the international level. International tribunals operate in a more fragile ecosystem, as we can see, than national courts. They depend on states for the nomination of candidates, for cooperation, for arrests, for evidence, for the enforcement of their decision, and for their defense itself. They are not only vulnerable to a lack of cooperation, they are also face organized campaigns aimed to undermining their proceedings without addressing the legal substance of their decision, using state power to directly sanction judges, restricting their movements, blocking access to financial systems, threatening their families, or warning allied states to the cost of cooperation is very different from political criticism or not ratifying a treaty. It is not about refuting legal arguments. It is about raising the price of making those arguments. And as it had been said here, the most effective response to these challenges at the international level is systemic. But the systemic response does not begin in a crisis. It starts earlier, in the way states design their own process for nominating candidates for two international bodies. A candidate selected through a transparent process based on merit, technical competence, and civil society participation will arrive at their post with autonomous legitimacy. If this legitimacy does not rely on any political actor's support, it cannot be taken away when the judge makes an inconvenient decision. Let me give you an example. In Argentina, in 2025, we approved a new mechanism for selecting national candidates to elections for UN human rights treaty bodies and for the Inter-American system. This process is based on principles of transparency, merit, technical competence, and openness to civil society. This mechanism is not aimed at ACC nominations, but the principles it follows are directly relevant here. A state that selects its international candidates with rigor and openness not only improves the quality of its nominees, it also contributes to the future independence because they are granted autonomous legitimacy for the very first day. Organizations like the ICCBA fulfill a critical role that states alone cannot. They articulate the response of the legal community with a specific credibility that state diplomacy alone cannot replicate. There is one more protection, the most fundamental of all. Independent courts defend themselves by being exactly what they are claimed to be. Every proceeding that meets the guarantees of due process, every decision that applies the law consistently, even when it is inconvenient for powerful actors, improves credibility. And credibility is our primary institutional defense, is the strength of the ICC. But all of this depends on the coherence of the states that claim to support these institutions. If we defend them only when they act against our adversaries, but question their legitimacy when they act in ways that affect our allies, what we are defending is not the law, we are defending preference. And the rule of law cannot survive on preference alone. Allow me to close with this. Argentina's experience taught us that justice can be eroded, but it also taught us that justice can be rebuilt. And every serious institutional reconstruction begins the same way, by taking the rules, the procedures, and the responsibilities seriously again. In an area of polarization and institutional fatigue, this is my conviction. We do not need less law, we need better law. We do not need less international justice. We need greater legitimacy and deeper commitment to its principles. We do not need less judicial independence. We need better institutional design to make it real, because when the law retreats, freedom does not advance. What advances is power without restraint, and we are seeing it today. And in the end, judicial independence does not protect judges. It protects citizens, minorities, and those who have no power other than law itself. It also protects freedom, property, and investors. Ultimately, it protects the sustainable development of the West. Thank you so much.
Thank you, Doctor. Ambassador, you heard Dr. De La Torre talking about the need for courage, and Judge Haller quoting the coalition from the ICC that mentioned chilling effects. So do you see a risk that the failure to respond robustly could create a chilling effect on nationals considering international justice roles?
Thanks so much for the question. And I mean, I do. I do. And I think in the sense that I think anybody who is interested in working as or putting themselves forward as a candidate or potentially working with the court has to be aware of that reality. I think there's no point sugarcoating this. I do think that for individuals, it's got to be a difficult decision because you have states with great power that are clearly targeting the court as an institution and targeting individuals within the court themselves as well. I mean, obviously, this is wrong, but I also think at the same time we have to be frank about the world in which we live and the pressures in which individuals might have to face as they make decisions about what they want to do. We are fortunate, I think, in this institution to have individuals of great conviction, of great courage. I mean, I think I'm lucky today to be sitting on a panel with many of those. The phrase also that's come up today a couple of times about the court's approach is resilience and adaptability. It's asking a lot of individuals to assume that, but I also think that's what we're asking. And I think that is the world in which we live. I wanted to add a couple of things to that, though, too, because obviously states have a role to play in this, of course, and we talked a bit about that. I actually think as well, though, that civil society has an exceptionally important role to play. And I know civil society has been with the court from the beginning and supportive. This is a discussion today that's focused particularly on the bar. The bar's role is crucial in the sense that lawyers often play important roles within their own societies, sometimes explaining what the rule of law is and its significance, and explaining how courts function and the role of why independence is so important as well. So I do think there are things that can be done as well, whether it's educational or otherwise. And the other part, and Judge Holder's comment actually made me think of something, another comment that you had made this afternoon, which was about the important decisions that have been made at the court during the course of its history already. I do wonder sometimes if it wouldn't be helpful, and I actually don't know how we reach this, but for some of the court's work to be more visible, because that in and of itself is potentially helpful, because the court should be seen more broadly as an institution that is of benefit to everybody. That's of benefit to everybody because it's part of the international judicial and legal infrastructure, which has been said a couple of times along the way, is foundational to the rule of law, and the rule of law at the end of the day serves to protect us all in some ways. And the court's work, and for having people understand the significance of that work, I think in and of itself, it's a little bit indirect, but can also be helpful in making the court seen and its individuals seen as individuals and institutions who ought to be respected for the work that they do and protected from attacks.
Thank you very much, Ambassador. And perhaps I can just move swiftly on to the UN Special Rapporteur. And Madam Rapporteur, you've heard, of course, over the course of this evening, including from the ambassador again of the chilling effects, of course, that these coercive measures are having, both within and, of course, beyond the court itself. And of course, we've heard the resilience and adaptability is really not enough. And as UN Rapporteur, a Special Rapporteur, are you able to assist us with what the UN, of course, and member states of the UN can actually do? Of course, the ICC is not a UN organ. It's a treaty court, but of course it works with the UN, and they have shared goals that we've heard about, of course, maintaining the international rules-based order, ending impunity and atrocity crimes. So what practical steps do you envisage that member states of the UN can actually embark upon in order to protect the independence and the effectiveness of this court whilst facing these threats and sanctions?
Thank you for that set of questions. And I think the discussion has been so rich already, so I won't take too much time. But I think the first major thing is to insist on the centrality and the continuing importance and bindingness of international human rights law. So judicial independence, we've already talked about how it is an inherent part of human rights law. And this system of law is operating all the time. It doesn't get knocked out because of unilateral actions of a member state. So I think that all of the kind of spokespeople who comment on this issue need to be reminding states of that, need to be reminding just the general public of this, so that human rights of independent judges and prosecutors remains at the center. And as a number of the judges have already said, reminding everyone that judicial independence is not about the judge's prerogatives. It's about the protection of the system in order to make sure that the rule of law can protect the most vulnerable. So lots of specific things that can be done. If it seems important, there could be a legal opinions, for example, from the Office of Legal Affairs to clarify states' obligations, not to obstruct cooperation with the ICC, to ensure that sanctions cannot chill witness support, evidence sharing, legal representation, and especially, of course, victim participation. There is, of course, the possibility of seeking an ICJ advisory opinion. I don't think there are really huge legal issues that remain unclear here, but having an advisory opinion from the ICJ could make it much clearer and set out the reasons why unilateral criminal enforcement and sanctions that are aimed specifically at independent judges, prosecutors, and international justice personnel do violate the UN Charter, human rights treaty law, customary international law, and even larger principles at work like the obligation to prevent impunity. Now on to host states. I think that we have seen host states like the Netherlands, of course, specifically, to step up and try to take specific steps to ensure that the ICC can continue to work, continue to do its banking, its insurance, its travel, digital services, and all of that. And I think that's so crucial. I would recommend that member states start to do more to reach out to companies in their jurisdictions, and also headquartered in their jurisdictions, to understand that implementation of unilateral sanctions is not necessary and also can put them in the position of colluding in attacks on judicial independence. I think it's important that states be clarifying those obligations to those companies within their jurisdiction. I think there may need to be some kind of specific protection mechanism. So, how can judges and prosecutors ensure that in the future, if this happens, they have that kind of immediate support? We've already heard from the judges that there was a lag, and then I think that lag in part is because of there's a bit of shock when this first happens. We now know that this is something that more than one member state is doing. So there may need to be a specific sanction mechanism, sanction sort of quick response mechanism. I also want to say that, as Judge Ibanez said, and I think this is so important, there needs to be legal support and representation for those sanctioned. And I can say also, and as has been discussed in the press, so I'm not saying anything new here, that includes those who have been sanctioned, who are other kinds of officials. And here I want to specifically mention the Special Rapporteur on the Occupied Palestinian Territories, who has herself been sanctioned for cooperation with the court and really in many ways left alone to defend herself. So just to move back to member states for a second, I think that the implementation of the blocking statute is very important right now. There's been enough time to think about it. I think it should move forward. I think that there should be much more political support, vociferous political support, and that includes the basic legal obligations of member states, like complying with court orders, ensuring that arrest warrants are actually implemented, making sure that the court has the funds it needs to face these really unprecedented but unfortunately ongoing attacks and challenges. And finally, I would say that I think it really, again, is so important for all of the bar associations in the world, and I'm very pleased that this discussion is by the ICC Bar Association, to be talking with the governments in their own states to ensure that they are protecting these international justice mechanisms and calling on their states to step up really and to do more to ensure that this system can continue. Otherwise, it becomes a real attack on the entire system. And so I think that much more can be done. It needs to be coordinated, and it needs to be in the name of judicial independence as a core norm of the international rule of law and human rights.
Thank you very much.
Judge Ibanez, you heard the Special Rapporteur giving a few concrete ideas of how to respond or how we could improve the current situation. And we heard today how we're witnessing a shift where judicial independence is no longer challenged only internally within states, but externally through geopolitical pressure. So my question is, are our current legal frameworks equipped to respond?
Thank you for the question, Milene. When I listened this, I was thinking legal frameworks in plural. Well, I start in singular with the current legal framework of Rome Statute. I would say that not. Categorically, no. Rome Statute has not been designed to contain any measure of protection, let alone of reaction against these external attacks or measures of pressure. This is a relatively new phenomenon. And when you review Rome Statute, you go to Article 40, where barely, I would say, judicial independence is considered as a duty linked with some prohibitions for the judges. And then you go to Article 3 of the Judicial Code of Ethics, and you can see also that in judicial independence is considered as a duty linked to integrity or moral issues. But you cannot see in any part of Rome Statute any article that could, from which it will be able to do something, to have some legal reaction against this kind of external pressures. So I think that at some point it would require some amendment of Rome Statute in order to, to have some normativity, some articles, some measures, some provisions that could allow this court to react at least in a legal way. Regarding the other legal frameworks around the world, I would like to say that even if we recourse to Article 70 of Rome Statute, taking these pressures as offenses against the administration of justice and as a form of retaliation, we wouldn't resolve the problem, because this action wouldn't remove the sanctions or remove the illegitimate judicial proceedings against judges. So this is a question that needs perhaps legal innovation. We need to think more about this, but all in all, we need political will because, as Margaret Satterwhite also say, it's indispensable for this court to have any means or to go and recourse to have any means to defend us and this court legally before tribunals. It is really, really important. And also for state members, not only to react as parts of a treaty, but to act as a truly defenders of rule of law, as a truly defenders of this system. This court is your child. Defend your child. But how you defend your child? Not only with statements, enough for statements, thank you, nice statements, but enough. We need concrete measures. You could recourse, as some of the lawyers of the ICCBA have written, you can recourse to the International Court of Justice, for example, by presenting a cause that deals with the interpretation of treaty, because these measures are impeding the completion of the activities of Rome Statute treaty. This is an example, just an example, or to recourse to an other any measure where you could show that you really have the force because you are 125 states and you have the force to stop this arbitrariness, this abusive use of the power. That's my response.
Thank you.
Thank you very much, Judge Binez. We will be moving very soon to questions from members of the audience. So please, if you have questions, if you're thinking of questions, do start formulating your questions. And if you, in due course, we'll be asking you to raise your hands, and there are microphones in the room that will be passed round in due course. But hopefully we have a couple more minutes, and I'm afraid it's only a couple more minutes, sadly, to try and ask a couple more questions, and I'll turn to Judge Holler first, if I may. And of course, what perhaps I'd ask you to focus on, if you can, Judge, is really what can judges and judicial associations and other professional associations do in the face of such threats, both nationally and, of course, internationally? Thank you.
Yes, thank you for that question. As well. A lot has already been said today about that. I think the first thing that we have to realize and present, I would say, to our colleagues at the national level is that the international and national rule of law are very closely connected. This is a pet peeve of mine, simply because when I go and talk to colleagues in national jurisdictions, be it judges or lawyers, I'm not always sure that that is completely understood. And I think that is very important to emphasize. And if the legal professionals understand it, the public very often doesn't. So for them, attacks on international judges far away in The Hague doing work that they don't really understand, I think it's very difficult for them to see how that may impact their lives. My argument is that the two are related, and undermining the judges and the rule of law at the international level will inevitably trickle down to the national level and vice versa. To your question on what can judges, other legal professional organizations do, I think the first thing to understand is that defending judicial independence is a shared responsibility. It is not just something that we as judges and justice professionals work for, but we have to make it clear to the general public why this matters. Why, as it has been said before, judicial independence isn't a shield for the judges. It is a guarantee for those who come before them. And perhaps some concrete measures, some of them have already been mentioned. One, I absolutely agree with the Special Rapporteur and the Ambassador, is about speaking up. I think we as judges at the ICC have a duty to speak up and in defense of the rule of law. I think national judges, national professionals should do the same at the national level, and that is simply because someone from I don't know, from Argentina will be able to explain to their public the attacks on the International Criminal Court and the rule of law better than if I go and discuss that. So I think that matters. And as justice professionals, we do have a certain authority within our countries. We are, I hope so, being paid attention to. The second thing is what has already been mentioned by the special rapporteur and by Judge Ibanez, is I think we are seeing for international judges a lack of protections. At the national level, if judges are being attacked, there will more often than not be constitutional guarantees. There will be avenues to challenge that. They might not be perfect, they might take a long time, but they exist. For international judges, there are far fewer. We do not have standing before international courts, for example, or most of them, or it would be a very complicated process through our national jurisdictions. So I think thinking ahead when these attacks are happening, whether states, international community shouldn't legislate and prepare for these type of events, that's something that I would perhaps mention. And then the third one, I think the ambassador has put it very well. I would phrase it as effective communication. I think it is true, and this has very long been sort of the center of a judicial response, is that judges speak through their judgments, and we do. That is absolutely the first thing that we do. But at the same time, we also have to understand that we live in a world where not everybody will be reading our judgments, will be reading about why the ICC matters, why international criminal justice matters. So I think strategic communication from the court is very important. Now, judges will be able to say some things, but of course we have to also show judicial restraint. That is very, very important. But I think for the ICC as an institution to have a strategy and to communicate, not just challenges, I underline once again, but also the achievements. I think that is very important, but because we have to make the public understand that the institution is working, that it is doing good work. It's not perfect by any means, and that it is worth defending. So that's something that I also feel quite strongly about, simply because I think the most effective tool, the most effective way to show defiance is doing good work. Issuing for us as judges persuasive decisions based on the law, and then the organization, the court, to communicate that work to the outside world so that it rallies in its support.
Thank you very much for that. And I will turn now, please, to George Prost. And you've spoken already about the work that Canada has done to try to protect your judicial independence. And the question I ask is really, what role do you envisage for a judge's home state in playing to safeguard the independence of their judges? And what is the balance to be had between state protection and the need to preserve the reality and the perception of judicial independence?
Thank you, and I'll try and be brief, because I think balance is always an issue when you're talking about judges interacting with states in your home state or other states in the context of an international court. Because unlike in national systems where it's just the thought of having a chat with a minister or a judge, I mean, other than through set mechanisms, is just so foreign. I know my foreign minister was asking these questions when she was going to call me. So I get that, but we're part of an international institution as well as being judges. And so it's much more common that we interact with our states and with other states on working methods on all sorts of issues, never on our cases or our core work. So I think the balance issue doesn't really arise, particularly in this context, because this isn't about talking or interfering with a judge in any way. It's about, in fact, the reverse, which is helping the judge, supporting the judge to protect the judge's independence. So I think that states are it's quite appropriate for a home state to be speaking publicly, privately about their citizen who has been subjected to sanctions, and about doing things to help, having conferences with them, about how the things are going. I think that's completely proper. The problem, I think, and the one that we have to really realize, is the inequality in the manner in which states will deal with. It's not going to be the same across the board for all states, and all of my colleagues who are sanctioned are not going to get similar. We're not going to get similar support. It's just the reality that states have different relationships. They have geopolitical factors. Geography determines how you're going to interact, how you're going to deal with the United States, how you're going to be able to support, and your willingness to do so, unfortunately. So that is why I think what is most important on this issue is two things. One, yes, you should support your own judge, but you should do it in a context where you're also at the same time supporting the principles and supporting the other sanctioned judges as well. So I was always clear about that with my government. I want them to support me, but I want them to do so also in a principled basis, supporting all of those who've been sanctioned. And secondly, this is another reason why collective responses, collective practical measures, if every state in the ASP is having a focal point, is taking these practical measures to reduce the effect of sanctions, there can be no suggestion that this is about individual states, trying to curry favor with judges. So that's what I have to say on that.
Thank you very much to you, Judge Prost, and indeed to all our panelists for their contributions and their really thoughtful engagement with these very challenging issues this evening. Before, of course, we close, we will like to open the floor to you, our audience, if you have any pertinent, pressing questions you want to ask. We see a hand there. That's wonderful. Perhaps we can have the mic heading. Thank you very much. I see two hands. Wonderful. Thank you very much.
Thank you very much. Cyril Lauchi. I've listened very carefully, and thanks for all panelists for everything that has been said. Extremely interesting. And I will not summarize because we have all heard, but Justice Prost especially has detailed a number of practical measures that could help, while describing also, and I hope I do not vary what you said, Judge Prost, or excuse me if I do, the shyness of the states in taking concrete measures to implement these practical to take those practical actions. Judge Ibanez Carranza has mentioned in her last intervention the possibility of a case before the International Court of Justice. But once again, I think we are facing a problem with the shyness of the states to take that initiative. And this is where I strongly believe that the court has a very wonderful wealth, an inner wealth, and that is its unity, and that is also the 93 nationalities of its staff. Because it's not only the 11 judges and prosecutors who have been targeted by sanctions that are supporting the consequences of it. Of course, they do that in the most significant way. But I think all the staff members of the court also are suffering at least anxiety and some consequences in their daily work. And as such, I believe all can be described as having an interest to defend. which means that the 93 nationalities can turn to their national states to request diplomatic protection in order to defend their interest that is at stake, not only with the US sanctions, but also the Russian sanctions as well. It works both ways. And there are ways to do that. There are ways to compel even the United States to come before the International Court of Justice by way of compromissory clauses. There is no issue about exhaustion of internal remedies because the judges here who are under sanction will tell me if I'm wrong, but I doubt you receive any notification of your rights to challenge the measures against you before the US courts. So that's not an issue of exhaustion of internal remedies. There are none because you are not US nationals. So all the conditions are there for initiating diplomatic protection. 93 ambassadors are waiting for the nationals of their state to come and request for that measure to be taken. It can be done by individual states, but they can also be the 93 states all together.
Thank you. We can take one more question, and I think Ms. Prost here has got her hand up. Thank you very much.
Thank you so much. Thank you to all the panelists. It was really a fascinating discussion. And first and foremost, I want to extend sympathy and support to the sanctioned individuals, some of which are on the panel. I feel that, as we know, these sanctions are unjust, and I hope that you will be able to fight them to the end. But the discussion made me think of a book that I read recently from Judge Theodore Meron, former ICTY judge, who talks about a lot of fascinating topics, but one of which is the pressures that he felt on his work as a judge. And of course, the pressures that he felt had nothing to do with sanctions, but they were nonetheless real and coming from states, coming from harsh criticism of his decisions, etc. And that made me think of the loneliness of being an international judge, because really you are in a unique sphere all by yourself. And I'm just wondering whether you feel that you are in a way disadvantaged by opposition to the domestic judges who can always turn to the Council of the Judiciary, en français, le Conseil de la Magistrature, this body of judges that align, that form a community and are, fostering collegiality. And I'm wondering, from the judge's perspective, whether you feel that this is something that you are missing in your functions and that you would think would reinforce the system, or on the other hand, if it would rather take responsibility away from states parties and other stakeholders. Thank you.
Thank you very much for that. Perhaps I can turn. Could I turn to the ambassador first? And perhaps ambassador, you might want to take the first point, perhaps, which was made by Dr. Cyril Lauchi earlier. It wasn't so much a question, an observation, of course, and it may well be that it's a quick one to answer. And of course, if anyone else then wants to step in.
I would just simply say thank you for the observation, actually, because I think, to put it in a very general sense, I think a lot of states parties are interested in hearing good ideas and suggestions and comments on steps that can be taken that are practical and helpful. So I will leave my kind of answer to that. And I am very interested in hearing, though, about the response of the judges. And maybe I'll just add a little anecdote of my own, which is my late father. I can remember telling me a story years and years ago about him meeting a judge in Canada, and the judge in Canada saying it was one of the loneliest jobs in the world because there were really no opportunities to talk about what you do because of the nature of the work and the independence of the judiciaries, and that it was such a hard task to take on. I remember being in law school thinking I'd like to be a judge someday, and then realizing, oh my gosh, no, that's really hard. These are really hard jobs. These are life and death, genuinely life and death decisions that are being made, hard decisions. So I'll stop there. I really want to hear what the answer is from the judges. Thank you.
Thank you very much. Judge Benez, you want to?
Very, very briefly, thank you Dr. Cyril Loach. Reading your post gave me hope, really. But I would like to say, in the part of diplomatic protection, that small countries like Peru and others, they don't want to do that. They want to take distance. Now, I have been experiencing this, to take distance from the sanctioned judge because she's compromised. We better be good allies of United States and Russia. Why should I support this judge? Is gone very quickly. So it's always a question of political will. It's always a question to be responsible with this. But thank you. Please continue writing. And to the second point, yes, we feel alone? Yes. I remember when I was with a lot of illusion when I came to this court and I say, oh my God, after all of this of 35 years of bad experiences or good experiences here, I'm going to go to the International Criminal Court, to the Cenacle of Justice. That will be nice. And then I came here and I faced arrest warrants, convictions, sentence from Russia, US political sanctions, whatever. And now I am being mandated to be resilient and adaptable. Well, yes, I am. We are. But is this enough? Not. But nevertheless, my colleagues and I, as judges, are sending with our conduct now a very powerful message. Justice is not conditional. Independence is not negotiable. And accountability will not be silenced. Thank you. Thank you.
Thank you very much, Atala.
I have just a little bit to add. I absolutely agree with my colleague, with what my colleague has said. With regards to the loneliness of the job, as many of you know, I've been an advocate for the past 20 years, both with the defense and the prosecution. And yes, being a judge is a more lonely job than being an advocate. But it is inherent in it. I think it's part of it, and that is how it has to be. With regards to the second part of your question, whether a sort of judicial council would help, I think national judges, indeed, it is a benefit when you have a judicial council that you can rely on, that you can discuss with. Judicial councils that take a stand very often in this sort of circumstances to protect judges and to protect judicial independence. But that is not to say that there is not a judicial community here. There is. There's a judicial community amongst the 18 of us that serve as judges here. There is also a community amongst those of us who are specifically affected. We meet, we share experiences, we try to help each other with what kind of solutions we find, and that so there is that, which is, I think, also very, very important. If there is a prospect of a judicial council at the international level, that would be welcome, but I'm not sure that's a realistic prospect.
Well, I very little I need to add to what were two very, very good responses. I did just want to make one comment on the first question, Cyril, that the fact that this has an effect on the staff of this court is very present in our minds all the time. I think we all make efforts as much as we can to try and reassure our staff, to talk to our staff. Those of us who are sanctioned are particularly well placed to sometimes, tell them funny stories or tell them, just to show that we fully understand it's an unfair pressure, but the staff is so brave and courageous, and their support means so much to us. So other things that could be done, like your ideas, that's great, but I did want to make that point. And then on the question, yeah, it's part of the job, but there is the community. It's an interesting development, the community of the sanctioned judges. How did you deal with the Uber problem? How are you booking your hotels? That kind of thing. That builds that community. And actually, what makes it less so is actually the support we have received from everyone, from the staff, from all the states, many times when I just go to a reception, almost everyone who comes up to me says, so sorry, what are you going through? So at least I do feel that there is this whole community of support. I actually get letters written to me, handwritten to me from Canada. I've had it now like 3 times from little groups, like an Amnesty chapter in Etobicoke or something, just write me to say, you know, good job, well done. And I'm sure others experiencing that. So it's that helps. So, but you know, it's always been a bit of a lonely job, but there we are.
Thank you very much to all our panelists, to our judges, to the ambassador, and to, of course, Mr. Rapporteur and Dr. De La Torre back in their respective locations. Unfortunately, the time is our enemy, and we are not able to take any more questions this evening. But I want you to please express your gratitude to our panelists for their contributions today.
Thank you so much.
And before we close, we also want to thank the presidency for their support. And Madam Vice President is going to give a short closing speech before James takes the floor back to close the panel. Thank you, Madam Vice President, for your support. Merci beaucoup.
Merci. Merci beaucoup. Je jette un regard furtif dans la salle pour voir que quelque part, nous avons quand même l'appui de la coalition internationale des avocats de la Cour pénale internationale. Et en cela, ça me donne beaucoup d'émotion. Je veux, en fait, lorsque j'ai reçu l'information, tout de suite, j'ai dit, j'allais venir. Tout simplement parce que avocat un jour, avocat tous les jours. Et je me suis rendu compte que ce sont des confrères et des consoeurs qui, quelque part, décident de nous apporter leur soutien d'une si belle manière. Et donc, à cet égard, je voudrais vous dire un grand merci, un sincère merci. Nous avons reçu les mêmes formations, nous avons reçu les mêmes profils, et puis les professions nous ont tout simplement départagés. Avocats, juges, mais nous restons les mêmes pour la justice. Et personnellement, moi, Madame Gansou, je suis devant vous ici à plusieurs titres. Devant vous en tant qu'ancienne avocate, membre de l'association des avocats de la Cour pénale internationale. Et je suis devant vous en tant que juge, mais je suis assise sur 2 autres sièges, poursuivis par l'un ou l'autre, en tout cas poursuivis. Donc, voilà comment je me présente devant vous, et c'est vraiment avec grande émotion, surtout après avoir écouté mes collègues présentes ici à la table, la juge Mossa qui est ici. Il ne manque que quelques-uns, mais je vous assure que ceux-là, ils sont aussi quelque part en train de travailler pour la Cour et de travailler sur cette question-là. Donc, un grand merci. Les questions qui ont été posées et auxquelles vous avez toutes répondu, chers collègues, ne me font pas penser que nous avons encore de leçons à apprendre. Ces questions et les réponses qui en ont été données ne me font pas penser que nous arrivons à une conclusion. Mais ça me donne tout simplement la conviction de ce que nous sommes en train de faire est réel. Et que nous avons tous prêté serment. Et ce serment-là nous demande de dire le droit et de ne dire que le droit. Et je pense
fondamentalement que c'est ce que nous avons fait. Et c'est ce qui nous vaut ce que nous sommes aujourd'hui. Nous sommes aujourd'hui des wanted, n'est-ce pas? Et je crois que lorsque vous avez travaillé dans votre vie et qu'un jour vous devenez un recherché, quel recherché, je ne sais pas. De toutes les façons, nous ne sommes pas des recherchés d'une certaine justice, mais nous sommes recherchés tout simplement parce que les acteurs politiques, nous restons incompris des acteurs politiques. Nous restons incompris des acteurs politiques. Et c'est pas ça qui va nous amener à ne pas continuer de respecter notre serment. De toutes les façons, la Cour pénale internationale a été créée sur la base de trop grandes souffrances. Et je ne nous vois pas aujourd'hui prendre des décisions qui nous font oublier Autriche, les camps de concentration en Allemagne, les victimes que nous voyons un peu partout. Ça ne peut pas nous amener à oublier tout ça. Et aujourd'hui encore, lorsque nous voyons ce qui se passe dans le monde, on peut se dire que l'histoire est têtue et qu'elle risque de se répéter s'il n'y a pas une institution comme la Cour pénale internationale. C'est vrai, moi j'ai appris à mon corps défendant, surtout dans le cadre de ce que j'ai été dans l'autre vie en tant qu'acteur de la société civile, en tant qu'ancienne membre de la Commission africaine des droits de l'homme et des peuples. J'ai appris que lorsqu'une institution travaille bien, ses intérêts ne sont jamais les intérêts des acteurs politiques. Surtout une institution qui se veut des droits de l'homme et qui se veut de la justice pénale internationale. Et c'est ça que nous vivons aujourd'hui. Donc, je voudrais continuer d'en appeler au soutien de tout le monde. Au soutien de tout le monde. On a parlé ici, on nous a donné l'essence même de la justice pénale internationale, l'essence même du droit international pénal et tout. On nous a parlé du fait que nous avons besoin du soutien des États, nous avons besoin du soutien des acteurs de la société civile et j'en passe. Ce que je retiens de tout ce que nous avons fait aussi, on a parlé de résilience, on a parlé d'adaptabilité, on a parlé de tout ça, mais ce qui me fait dire que les institutions, lorsqu'elles travaillent bien, elles n'auront jamais, ou alors qu'elles peuvent ne pas avoir l'appui des acteurs politiques. C'est ce qui se passe à la Cour pénale internationale aujourd'hui. Pour la petite histoire, lorsque nous venons ici, je les prends à témoin la juge Ibanez, la juge Bossa et d'autres collègues. Nous avons appris que la Cour pénale internationale risque de fermer parce qu'elle n'a pas la coopération des États parties dans le cadre de la mise en œuvre des mandats d'arrêt. Et tout de suite, certains d'entre nous ont réagi et ont dit, mais qu'est-ce que ça veut dire? La Cour pénale internationale n'est pas là pour jouer les gendarmes. La Cour pénale internationale est là lorsque les États parties eux-mêmes n'ont pas travaillé. Donc, vous ne pouvez pas penser que la Cour pénale internationale n'aura pas d'affaires. Nous l'avons dit. Mais aujourd'hui, je puis vous assurer que malgré les sanctions, et vous en êtes témoin parce que vous faites partie de la Cour pénale internationale, malgré les sanctions, le personnel qui travaille d'arrache-pied, les juges travaillent d'arrache-pied, malgré les sanctions, nous avons atteint un niveau de décision jamais égalé, sauf erreur de ma part. Sauf erreur de ma part, nous avons atteint un niveau de décision jamais égalé. Nous avons des situations dans nos files, nous avons des situations en train d'être étudiées et tout ça. Donc, ça veut dire que quelque part, les juges de cette cour, le personnel y compris, les avocats y compris, nous faisons de notre mieux pour l'humanité. Donc, c'est fort de cela que moi, je pense que ce que nous sommes en train de faire ici, nous pouvons le réitérer plusieurs fois. Nous pouvons le faire ad vitam aeternam, tant que nous n'avons pas la satisfaction qu'il faut, tant qu'il y a des conflits, tant qu'il y a des individus que nous pouvons poursuivre, parce qu'il faut que les acteurs politiques gardent cela en mémoire, que nous ne sommes pas là pour les États, nous sommes là pour les individus. Et tant qu'il y a des individus que nous soupçonnons, nous ferons notre travail. Tant qu'il y a des victimes, nous ferons notre travail. Donc, c'est tout simplement à cela que je nous appelle en demandant notre engagement individuel, mais collectif sur la question qui nous lie et qui nous réunit ici ce soir. Merci beaucoup, chers collègues, de nous avoir fait revivre un peu la situation. Merci pour le courage dont nous sommes en train de faire preuve. Et voilà ce que j'ai à dire, tout simplement. Merci.
Madame la Vice-Présidente, un grande merci por ces importantes remarques au nom de la présidence de la Cour ici. Your Excellencies, Your Honors, dear colleagues, before we close this event today, there are just some thanks that the ICCBA would like to express. And of course, we are immensely grateful, much gratitude to a whole host of people that we will not be able to actually name today. But I would like to take some time to thank, firstly, the ICC presidency for their continued support of this initiative. Particularly grateful to President Kane and to Vice President Apani Ganzu for their participation here today, but most importantly, of course, to hear from you, Vice President, and being someone that is representing the presidency here today, who also has been touched upon by these measures, these coercive measures that we've heard about. We are, of course, also grateful to all our panelists here today. We're most grateful for such deep insight, for their extraordinarily contributions to these difficult issues, and we have some little token of our gratitude for each of our panelists who are here today. Apologies to those who are at home or away from this place, but hopefully we'll get something, our gratitude to you in other ways in due course, Madam Special Rapporteur and Dr. De La Torre. Well, thank you. We are indebted to our honorable judges who, of course, have shown through their determined resilience, their fortitude, and the clarity of purpose here in participating with us here today in this particular proceedings, but also through their continued work at this court. And of course, we thank Ambassador, we thank Dr. De La Torre and Special Rapporteur for all your illuminating engagement, for your solidarity, and for just being able to show us a way out of these challenges. We're, of course, also grateful to Mr. Registrar. We thank you for your pertinent opening remarks. We thank you for your invaluable support of the organization of this event, and particularly engaging all the services, the support services, to help us in making this event run smoothly here today. We are thankful to our interpreters for all the work that they've done over 2 hours of interpreting without notes all the challenging issues that have been discussed, and we thank you for your great work this evening. We also thank the director of the ICCBA, the interns who have helped us here today. We are most grateful indeed to Naomi Martin and Julia Brown, who have been helping us over the course of this event. And of course, in liaising with all the various partners who have assisted us. As the ICCBA marks 10 years of standing, we will invite you to please check our website for updates on upcoming events, which of course includes hot off the press, I should say, an online AI training that is starting or happening on the 28th of May of this year, and booking will launch effectively as soon as this event finishes. We also have the Interactive Rule 74 Council training, which is an in-person and online training that is happening on the 22nd of June, and we hope that many of you will join us for that. Finally, I should say many thanks to all of you for being here today, for those who've joined us online from all over the world. Of course, your solidarity, your participation, your questions, and your concerns is something that helps both this institution, the judges personally, and of course, the ICCBA in putting together these events. Of course, if you want us to do more events like this, we will invite you to please take some time to join our association. There are lots of different ways in which you can be affiliated or associated with us. And of course, those who are members to opt to be active in the work of the ICCBA. We thank you all and we wish you all a safe journey home. And of course, I'll ask you to please thank our panel one more time.